If you or someone you know were recently charged with a felony here in Illinois, then you've got a long road ahead of you. A felony case can be frustrating, it can be difficult, it can be way, way, way longer than you expected, especially if you've never been through it before. I have often compared it to going through a maze. You know those mazes like that are in the cornfields, where you don't know which direction you're going, you don't know where the end is, but you know that you need to get through the end. You need to get to the end, you just don't know how. Kind of like what a felony case is, right? So what I'm going to do in this video is I'm going to give you the map. Now, you still need to get yourself through it or find someone to help you get through it, but I'm going to give you the map. And at least then you can stop, pause, look down at your map, and figure out where you've came from and where you need to go. That's my goal in this video, so let's dive into it right now. Hi, I'm attorney Derek Martin with Driver Defense Team. Our law firm fights a lot of criminal charges for people, many of them felony cases here in the Chicagoland area. What we're talking about today is, what does a felony case even look like? And I'm really trying to gear this to somebody who's never been through this process before. So I'm going to take it section by section, and you can skip around if you want, but I think it's really helpful for you to find sort of where you are in this process and what comes next. That's going to allow you to have a really good, educated, thoughtful conversation with your attorney. So here we go. The very first part of a felony case is the investigation. This can take many, many different forms. Sometimes it's very simple. An officer pulls somebody over and makes an arrest, whether that's a DUI or driving on a revoked license. Maybe they found something illegal, a gun, drug, something like that in the car. That's typically a pretty short time period for an investigation. They pull you over, something is discovered, they confirm that, and they make the arrest. Other times, that investigation can be very, very lengthy. Search warrants, confidential informants, wiretaps. You can sort of picture all these different things. It can go on for months and months or even years while a case is being built or investigated. But at some point, the officers make an arrest, and that is the second part of this, the arrest phase. So, you kind of know what this is like, right? You're put in handcuffs, you're taken to the police station. At this point, you do have some rights. You have a right to an attorney. You have a right to remain silent. At some point, you'll probably be read your Miranda rights. It's the right to remain silent. So this is a very important part, and obviously is what kicks off everything else, right? You've been arrested. Now you know. Here we go. So that, not too much more to say about the arrest portion of it. Everyone's experience is going to be a little different. It's never very fun, but now you know that here you go. You got yourself a case. If you're charged with a felony, you're not going to just be released from the police station. If you're charged with a felony, you're going to go to bond court. So that may happen the day after or even 2 days after you're arrested. You go in front of the bond court. And so that's issue number 3, or item number 3 here, is the judge at bond court is going to hear what's called a proffer. That's going to be the information, right, the facts as the prosecution sees it, as to why you're here in the first place, right? What happened, why they believe it's you, what your history is, all those things. Your attorney will say all the good things about you. Now, that can be a public defender that's assigned to you, or many people choose to hire a private attorney like ourselves to represent you at that bond court. Like I said, there's preparation that goes into it. You're presented in obviously the light most favorable to you, to the judge, and then the judge is going to make a decision. The judge is basically deciding what is going to be required for you to be released while this case is pending. That could be, on the low side, an I-bond. An I-bond is simply a bond. It's called on your own recognizance. You sign a piece of paper. You promise to show up in court. Nothing else needs to happen. You get released. On the high side of it, there is no bond, right? Meaning there is no amount of money or anything else that is going to get you released at this moment in time. And then obviously the majority of the cases are somewhere in the middle. The judge will usually, at least at this point at the point of making this video. Bond laws are changing often, but at the point of making this video, judges do often set a dollar amount. It's usually 10%, right? So a $10,000 bond would require 10% of that, or $1,000 to be posted. Once that is posted, you can be released, right? And so you've secured your release with that bond. There can also be many other conditions of bond. Things like the most common is electronic home monitoring, where they put an ankle bracelet on you. A curfew, so you can only leave the house during certain hours. Any other special conditions, not to consume drugs or alcohol, not to drive a car, you can check in with pretrial services. There can be a number of conditions to your bond, but what we're really talking about here is what is that dollar amount that is going to be required for you to be released. Next is a somewhat confusing portion if you've never been through this before. This section is where you are formally charged. That happens shortly after bond court. And so you can be formally charged in one of two ways. We're going to go through both of them here. Oftentimes, that will be by preliminary hearing. So I'm going to explain what that is. A preliminary hearing is in open court, so you'll be there. You have the right to have your attorney there, and also some witness. Most of the time, it's the police officer, the arresting officer, or one of the officers. Sometimes it could be another party, but most of the time, one of the police officers are going to be there, and they're going to testify under oath. And everything they say is going to be recorded by the court reporter. And so this is an important court date. And what's being established here is not whether or not you did it, not whether or not you're guilty or not guilty, but simply is there probable cause. Basically, can they continue with this? Can they formally charge you with this felony? I will warn you that most of the time they do find that there's probable cause. And that's because that bar is set pretty low. Essentially, and this is not a legal definition, but essentially what you can think of this as is the judge is determining, could a crime have been committed and could that person have been you? And so it's an opportunity for the officer to tell his story, lock them in on that story. And this is why you want an attorney for this preliminary hearing. Again, you may be signed a public defender, or you may hire your own attorney. But what we're going to do is we're going to sort of nail down their story. We're going to find the holes in it. We're going to find what they really observed, what they really saw. And they're going to be sort of stuck with that story, right, because of that court reporter, because this is all being transcribed. And so if their story changes later, well, we may have an opportunity to point to some credibility issues. So, like I said, most of the time, though, a judge is going to find, yes, there is a finding of probable cause after hearing this officer testify and be cross-examined, and then you'll move on. But there is another way that you can be formally charged with a felony. And in fact, many counties outside of Cook County will proceed with this other way, and they won't have a preliminary hearing. This other way is called an indictment. It's where a grand jury, this is a private jury of, I believe it's 16 people, will hear those facts from the prosecutor and again, make that decision, could a crime have been committed and could that person have been you? And again, most of the time, especially since you won't be there, especially since this sort of happens behind closed doors, you don't have an opportunity to defend yourself or tell your story at a grand jury. So yes, they often find that there is probable cause to continue with these charges, and then you are considered to have been indicted. There is a charging document that's presented. So those are the two ways. In some ways it's a formality, but in some ways it's really, really important that you engage good counsel prior to this so you can be prepared for it. Next, after you've been formally charged, is the assignment of your case. Up until this point, you have been in front of your bond court judge, you've been on your judge and maybe in front of the preliminary hearing, but that's not most of the time, at least in the Chicagoland area and the suburbs, that's not the judge who's going to hear your case overall. Your case is now being assigned. And that may be in the same courthouse and maybe not, depending again on the county. Cook County obviously moves people and things around a lot. But your case is assigned. And now that is the judge, and that is likely the prosecutor that will hear your case throughout the duration of it. So it's an important court date or important event. Next, you will actually appear in front of your judge. And that first time you do that, it's typically called the arraignment date. And so that's our next section, the arraignment. What this is where the judge basically tells you their rules, right? They're going to tell you, when you need to show up in court. They're going to tell you, that they can have a trial in your absence and what will happen if you don't show up in court. It's all the judge's rules. But maybe more importantly than that is that you are understanding, or at least getting the opportunity to hear those charges against you. Now that you've been formally charged, you hear those charges against you and you would enter a plea. It's always going to be a plea of not guilty. Again, this is a bit of a formality. At this point in time, you wouldn't plead guilty even if you wanted to, right? You haven't seen any of the evidence. So you hear the charges, you enter a plea of not guilty, and you hear the judge's rules, and that is your arraignment. Next, we move into the discovery phase. So discovery, if you're not familiar with that term, it's just the term that we use to capture all the evidence, right? All the evidence that can or may be used against you in this case is called the discovery. That can take many, many different forms. A police report is an obvious one. In the case of a DUI, any standard field sobriety test reports, breathalyzer reports. Videos are huge these days, whether it's a body-worn camera mounted to the officer, a dash camera on the front of the police cruiser, any sort of third-party, security footage, anything like that is part of the discovery. Many, many other reports, things like crash reports or medical reports are very common. There can be, gunshot residue, there can be labs for narcotics. There can be so many different reports and things that make up that discovery. But it's a really, really important part. It is what makes up the case against you, right? And so you need to spend some time fully understanding that discovery, and it does take time. This is the point where people often get frustrated because we don't usually receive that discovery in one nice little package on the very next court date. No, unfortunately, it can take months or even years in some cases for that discovery to be turned over. We are entitled to it, so we will get it, but this is something that can take quite a bit of time. In the end, you will get all the discovery, and in the end, you absolutely have the right to review that evidence against you, but the timeline or the process of it can be a bit frustrating. So another phase, or the next phase that I want to talk about, is any pre-trial motions or pre-trial hearing. This is where the sections kind of get intertwined a little bit, because the discovery does not have to be complete for you to have this motion. There should be a substantial portion of it where you understand, sort of what it is, and there's no surprises still hanging out there. But a pretrial motion is where you attack the discovery or the arrest in some manner. There are many motions. I'm not going to go through them all here. But essentially what you're doing is you're attacking that information, saying that it's deficient in some way, or you're entitled to something additional that you didn't receive, some sort of attack on that discovery. And the hope is, obviously, if a judge rules in your favor, either discovery will be limited or kept out, or maybe it's missing, and that may prove fatal to the prosecution's case and ultimately win your case. So this can take a number of different forms. A motion to quash and suppress arrest is a very common one that people reference. But again, this is something that can only sort of be determined after reviewing the discovery, and is something that you and your attorney really, really need to discuss and understand how you wish to move forward. So those are the pretrial motions. Also, simultaneously, perhaps with that, or at least shortly after those pretrial motions have been ruled upon, if there are any, your attorney is going to talk about a plea. Now, not every case is going to plea. Some people say that you're never going to plea no matter what, and I certainly respect that. However, in most cases, your attorney is going to talk behind the scenes with the prosecution about, if we were to resolve this case, what would that look like? Are we pleading to which charges? Are there reduced or amended charges? What would that sentence look like? How are we going to sort of reach that? Most of the time, your attorney owes it to you to sort of explore that, right? You can't truly make a decision unless you fully understand those things. This can be sort of a minor conversation and maybe a minor case. It can certainly be a much more serious conversation with supporting documents and mitigation and things like that in some other cases. But that is a significant milestone, and that is sort of the offer or the plea negotiations. If plea negotiations are rejected or refused or they don't bear any fruit, in other words, there will be no plea, typically what happens is a trial. That trial can be in front of a judge or a jury, but basically what they're determining is guilty or not guilty. So obviously a trial is great when you are found not guilty of all the counts, not so good if you are found guilty. So this is, again, something that I think most people sort of understand how this works. Not all cases go to trial. In fact, most cases do not go to trial. But certainly a large number of them still do, and it's obviously a very important part of this. This is where you prove your innocence. So again, you win the trial, good, and don't win the trial, not so good, right? So again, this can only be something that your attorney can answer for you. I can't possibly tell you anything about your trial. Only the people really close to your case can tell you about that. If you are found guilty or you plead guilty, there will be a sentencing phase. That's one of the last things here. And that is, what is the penalty? What is the punishment for this? Because now you have pled guilty or been found guilty to some sort of charge. And so what does that mean for you? What is the outcome? Is that jail, prison? Is that, community service? Is that a fine? It can be many different things. Finally, there is the appeal. Again, you probably know what this is. To keep it really simple, there are higher levels of courts that you can appeal to if you believe something went wrong or there was some sort of issue, substantive issue on your case. You can appeal to a higher court and have them possibly hear that and rule on that to overturn what happened at the lower court. That's everything. That is a felony case in summary. And so it may be helpful to sort of jot those down or break down what those issues are. I think the best thing you can do is identify exactly where you're at in this process, or have a conversation with your attorney about exactly where you're at in this process. You can also sort of look around the bend a little bit in this maze and see what comes next or predict what may come next. If you are in this process, especially in the beginning of this process, and you're looking for an attorney to represent you, we'd be happy to talk with you about that, talk a little bit about the strategy, talk about what you're facing, and talk about this process with you. Now, if you're already deep into this, we can't help you. In fact, we shouldn't help you. We won't help you. The best person there is your attorney, who is closest to this and knows what's going on. But if you do want to talk, we're happy to help you if you're in the early phases of this. I hope that you found this helpful. It is my sincere hope that this brings you some sort of comfort as you move through this very awkward, very confusing, very difficult process. So I wish you the best of luck on your case. Thanks.